America's highway system touches the daily lives of everyone living in the United States. Whether getting to work or the market, visiting a national park, or family and friends, our public roads take us there. The Federal Highway Administration, or FHWA, works with partner agencies such as state and local departments of transportation that design, construct, and maintain our public highway systems. Together, we ensure fair and equitable delivery of our programs, activities, and services. Therefore, public transportation agencies must comply with civil rights requirements established for these purposes. For local public agencies, or LPAs, these requirements primarily include Title VI, Disadvantaged Business Enterprise, or DBE, and Americans with Disabilities Act Section 504, or ADA Section 504. Agencies that administer FHWA contracts must also ensure non-discrimination on construction contracts. The FHWA administers civil rights requirements through its Title VI, DBE, and ADA programs. Let's review each of these civil rights areas. The Title VI program, founded on Title VI of the Civil Rights Act of 1964, requires that no one be denied benefits, services, or contracts on the basis of race, color, national origin, sex, age, disability, limited English proficiency, or low income status. A successful Title VI program gives the public the assurance that agency services and resources will be allocated fairly and any negative transportation impacts shared equally. The Title VI program includes a signed agreement called Assurances between your agency and the State Department of Transportation that obligates your agency to prevent discrimination in all its programs and activities. It also includes a system of compliance, monitoring, and enforcement actions, which is typically contained in an implementation plan. Another program that promotes equal opportunity and diversity in the transportation industry is the DBE program. This program gives socially and economically disadvantaged businesses equal opportunity to compete for and obtain federal highway-funded contracts and business development opportunities. Agencies must set DBE participation goals, monitor program activities, and report levels of participation. When a contract includes a DBE goal, the agency must verify that its contractors have made an adequate good faith effort to provide DBE subcontracting opportunities and that the DBE subcontractor is performing a necessary and commercially useful function on the project. The ADA Section 504 program administers civil rights protections for individuals with disabilities. Public agencies must ensure that their facilities are accessible to and usable by persons with disabilities, regardless of whether federal funding is involved. Public agencies must conduct an inventory of their curb ramps, sidewalks, and other public rights-of-way facilities, identify those that are non-compliant, and develop a program access plan or transition plan for making corrections. Public agencies must also appoint an ADA coordinator and disseminate procedures that someone can follow when filing a complaint. Non-discrimination on construction contracts is an equal employment opportunity and affirmative action requirement that protects applicants and construction workers from discrimination based on race, color, national origin, religion, sex, age, and disability. Compliance prevents bias and promotes fairness in all subcontracting and employment practices, including recruitment, hiring, training, and termination. Non-discrimination on construction contracts requires agencies to include an FHWA-provided non-discrimination provision in federal aid contracts using Form FHWA-1273. It also requires that agencies ensure prime contractors appoint an equal employment opportunity officer and that prime and subcontractors disseminate a non-discrimination policy and monitor personnel actions. Programs that protect and enforce the civil rights of individuals, businesses, and entire communities are priorities for the federal government. Every transportation agency receiving federal aid financial assistance must be unbiased in its actions. It must also promote fairness in all employment and contracting practices and in making decisions allocating transportation services. Your agency's compliance with these Civil Rights Program components is its first line of defense against civil rights complaints, lawsuits, and the potential loss of FHWA financial assistance. For additional information on FHWA's civil rights programs, please continue to explore the many resources available on this website.